Joining me now from our bureau in Washington, D.C., international law specialist and constitutional attorney, Bruce Fein. Bruce, it appears to me, I want your opinion, of course, but it appears to me the special counsel is building a case involving Donald Trump's orbit. This would be Roger Stone, and I think quite possibly the Trump family. This would be unconstitutional, what he's doing. I think you would agree with that. But I think what he might do in the end with this information, and or the Democrats might do, is indict President Trump, which again would be a violation of DOJ policy, but indict President Trump in the court of public opinion. I think that's where this is going. Where do you think it is?
Well, I think we need some background here, Graham. Under the writ that justified the appointment of Mr. Mueller in his investigation of so-called Russian collusion with the Trump campaign in 2016. Mr. Mueller is required to comply with department policies, and the department in year 2000 said explicitly a sitting president cannot be either indicted or prosecuted for a crime, that if there's wrongdoing, it's to be investigated by a sitting president, by the House of Representatives, which has the sole power of impeachment after the president is no longer in office. Obviously, criminality could be pursued then. So that Mr. Mueller, as we speak, has no authority to accuse or to prosecute Mr. Trump. Now, also, with regard to his authority, insofar as he prepares a report that chronicles his findings, factual or otherwise, whether they led to indictment or not, that report is to be delivered to the Attorney General. It doesn't, it's not delivered to the public or the House Judiciary Committee or anything else. So it would really be up to the Department of Justice at this point, not Mr. Mueller, whether or not, adverse, scurrilous, defamatory statements ever got into the public domain. But we're in a very odd situation, Graham, because the legality, the constitutionality of Mr. Whitaker, the acting Attorney General's appointment, is now under a cloud. He's clearly a principal officer, and Article 2 clearly says principal officers need to be confirmed by the Senate. He's appointed temporarily, if you will, 270 days under the Vacancy Act, but the Vacancy Act can't trump this Constitution. So if that were true and Mr. Whitaker is not serving properly, then it would be Rod Rosenstein who would decide what to do with that report. And it's also conceivable that next year, with the Democrats in control of the Congress and Jerry Nadler running the Judiciary Committee, they might try to subpoena it and make it public. Well, so we have all these imponderables out there, so we don't know exactly what's going to happen. But many of those decisions really are outside the control of Mr. Mueller.
Nadler has promised his first witness as head of the committee is going to be the acting Attorney General. But you bring up an interesting point here, because there is an argument to be made that the report, when there is a final report, number one, it should be out of the public domain. This is an Article 2 branch of government function. It should stay theoretically within the Article 2 branch, depending on whether there's recommendations for prosecution, indictment, etc. But the bottom line is we have an acting Attorney General, and Mr. Mueller now reports to the acting Attorney General. He does not report to Rod Rosenstein anymore, correct?
That's correct, but as far as we can tell, the acting Attorney General, under the regulations, has the power to overrule Mr. Mueller on any important decision. And at least at present, there's no indication that he has, whether it's related to the sentencing memo that was delivered with regard to Mr. Flynn or otherwise. And this, as a historical fact, because I've been around a long time, including involved in Watergate, the Watergate Special Prosecution Force, when it completed its final report, it decided it would not name anybody and publicly criticize anybody who wasn't actually prosecuted and had an opportunity in a trial to rebut any adverse allegations. So that was not made public. Of course, we're living in different times today and in different standards, but it's ordinarily thought that the Special Prosecution Force in Watergate is kind of the gold standard. So if that's followed, it's kind of unfair to put out a report that accuses people of something, but there's no opportunity to respond because there's no trial.
Want to see more videos like this? Click on the link below and subscribe to One America News on YouTube, and call your cable provider and kindly demand that One America News is added to your lineup. Call and subscribe today.